Hi everyone, this is Matt with ESI Survival Guide, and I want to welcome you all to a video discussion with Jonathan Armstrong for February 4th, 2021. But before I unleash my excitement, let me just give the old obligatory disclaimer that the views expressed on today's session are those of the individual interviewers and interviewees in our own individual capacities only, not those of our respective employers. So I also want to direct you to the disclaimer on the website, somewhere down at the bottom. There's lots of good legalese in there. And with that, Mr. Armstrong, I'm so happy to have you on the guide. And just to note, I feel like we should mark this for history. You are the very first interviewee of the brand new 2021 launch of the guide. So thank you so much for being here.
Oh, fantastic. I'm honored. Thank you for inviting me virtually into your penthouse.
Sure. So I guarantee you the weather's a lot different in reality. If I could turn the camera around, you'd see a much different picture. It's more like Mad Max Beyond the Thunderdome in snow. But if I had a virtual fruit basket, I would definitely give you one. I feel like I should have some green room gifts for my guests, but maybe once we get out of the COVID era back in person, I can do that. But yeah. So for our viewers out there, let me just flatter you for a second if I can. Jonathan is a partner with Cordery Compliance based in London. He's an experienced lawyer focused on tech and compliance, which is exactly why he's visiting us today on the guide. He's a UK data law expert, but his expertise is global. He's handled legal matters in more than 60 countries involving various cutting-edge tech issues. He's a prolific author. He's a frequent broadcaster. He's appeared on BBC News 24. And if I can go through some other things, so 2016, Analytica ranks Jonathan the 14th most influential figure in data security worldwide. 2017, Thomson Reuters lists him as the 6th most influential figure in risk compliance and fintech in the UK. In 2019, you then received the Security Serious Unsung Heroes Award for your work in information security. Just this past year, you were featured by Analytica as one of the world's top 100 influencers in cybersecurity. So my first question to you, sir, is when are you going to stop slacking off and get this whole data career moving? So, and I noticed a gap there in 2018. So you must have taken that year off so your colleagues could get some accolades. So we all thank you for that.
It's like a fine wine. Maybe I have just 3 years in 4 I can produce.
Exactly. But Jonathan, this session's going to be for beginners and experts alike. So if any terminology comes up that I think needs to be defined, I might ask you to do that. I'll also reference the data protection glossary on the Cordery site as a very solid resource. I'm going to link to a bunch of commentary from the Cordery compliance site, as well as several other resources in the text. So let's go ahead and just jump on in, if that works for you, Jonathan. Ready to go? All right, so on December 15th, the European Data Protection Board adopted its statement on the end of the transition period for Brexit, and basically reminding, if not warning, that the UK will not be applying the GDPR as of this year. So that statement went on to remind us that the UK does not have an adequacy decision pursuant to Article 45, and also expressed some caution with regards to relying on Article 49 derogation. So then 9 days later, after that came out, the European Commission came to an agreement with the UK concerning cooperative efforts going forward in light of Brexit that went into effect on December 31st. That's the trade and cooperation agreement. So still no adequacy decision, but for our discussion, we're focused on eDiscovery and eDisclosure, which inevitably involves the collection of personal data and the movement of that data. So my first question, what does this trade and cooperation agreement say about the transition of data between the UK and the EU?
Yeah, so I think as you sort of as the picture you've painted is correct, I think it's a complex picture. First thing I think to say is that there is a difference between guidance from regulators and obviously the EDPBs, if you like, the super group of regulators. But there's a difference between guidance and adequacy decisions. So guidance comes from regulators and is non-binding. The courts can and do overrule that guidance. Adequacy decisions are made by the Commission, effectively like the executive of the European Union, and they can also be challenged, as we know from the Schrems 3 case, Schrems 2 for the non-purists. So we know that adequacy decisions can be overturned as well. And obviously, we don't have either of those. We have a sort of temporary treaty, if you like, that lasts until the end of April. So not long to go on that treaty, with the possibility of it being extended till the end of June if an adequacy decision is close. And on the adequacy decision itself, it depends on who you believe as to how advanced the preparations for that are. Some at the European Commission say, yep, we're getting on with it, we're making good progress. Others at the European Commission tell you that that's not necessarily the case and that we're at the start of the process, not midway and not towards the end. At the same time, we have, I personally would say, unhelpful comments from one UK politician in particular, sort of saying it's a done deal, and I'm not sure we even need an extension to April because the Commission should be able to reach an adequacy decision in March or April at the latest. I think that's optimistic, but I think an adequacy decision, the more I look at it, ends up being a political decision, not a legal decision. And for that reason, there are a number of uncertainties. I think the first is, I think the EDPB are wrong. UK has implemented GDPR, and we have it stitched into our domestic legislation by virtue of the 2018 Data Protection Act. So there's no changes there as yet. But we could get a stage where a UK politician is found to be in breach of GDPR and says something stupid, like GDPR is a stupid piece of legislation and we're going to repeal it as soon as we can. If anybody says that between now and the adequacy decision, I think the adequacy decision is in real trouble.
I've read a few pieces in the press in the States that talk about some of these fighting words going back and forth and stating exactly what you said, that something could happen in the interim where someone says something, out of key, and all of a sudden there's kind of an unraveling. So what happens? What happens if April comes, June passes, and there's still nothing? Is that even a remote possibility, you think?
I think it is more than a remote possibility, and I think there's no guarantee, in my view, that we'll get to April and we'll get to June with plain sailing. And this isn't a party political point. I think if you took almost every other administration whilst I've been alive, whether that be Blair, Brown, Thatcher, Cameron, you'd say that the likelihood when there's a precarious negotiation of a UK politician doing something stupid, which would prejudice the temporary deal, was low. And unfortunately, and it doesn't give me any satisfaction to say that that isn't the case with this administration. So there are a number of politicians in this administration which some people might feel have been promoted above their ability. And the difficulty is that they're the type of politician who react off the cuff. And I think if they react off the cuff, then adequacy has real problems. And I think even the temporary deal has real problems because the deal effectively commits the Johnson administration to keeping the status quo going, keeping GDPR principles there until the adequacy decision has been reached or the April deadline or the June deadline. So I think there are many complexities along the way, and I think from an eDiscovery point of view, it's one of those horrendous difficulties where it doesn't give us certainty. And why eDiscovery is different from most other things is you're trying to get the data from one place to another lawfully because you've got an obligation, let's say, in a US court. Your difficulty is, of course, if the deal's revoked, theoretically at least, that transfer becomes invalid, then you're in a world of pain. You may have disclosed documents that you're no longer entitled to process. So there's all sorts of complexity where eDiscovery, more than some other transfers of data, needs that certainty that the law just doesn't give us at the moment.
You talk about politicians being promoted above their abilities. That's definitely something that we've had experience with here in the States recently. But I wonder too, you said before, and I really want to get into and unpack these adequacy decisions and kind of the process. But you talk about how the UK under the 2018 Data Protection Act, you kind of already have these GDPR style requirements in place. So what's really going to change in terms of what, I'm a UK company, I regularly transfer data. Are there any major differences between GDPR and what's come to be known as UK GDPR?
In practical terms, not. I mean, the the complexity is in some respects should be well, the adequacy decision should be in many respects plain sailing, and there are a number of reasons for that. The UK has had data protection legislation since 1984. It predates the directive, which in terms predated GDPR. So data protection law is a core fundamental piece of UK legislation, regardless of the EU relationship. Obviously, the UK regulator has got some good fines on the board. So I think 2 of the top 5 fines last year were from the UK regulator. So there should be no criticism of the law. There should be no criticism of enforcement. In some respects, UK law goes over and above GDPR because it has specific criminal offences. We've talked about some of those that apply to eDiscovery in the past, like re-identifying anonymized data, like refusing to give data back when the data controllers ask for it. And those provisions are unique to UK law and are stronger than GDPR. At the same time, the EU has granted adequacy decisions to other countries who, on any objective measure, have less strict laws. And one of the and some of the European Commission countries that are making the decision, their laws aren't as strict. You could look, for example, at the debacle, if you like my French, Matt, in France just last month over the drone surveillance to enforce COVID, where you've got this very frustrated statement from CNIL, the French data protection regulator, to say, more or less, we wanted to bring a fine, but the French government restricted data protection law to make sure that whilst we're an independent regulator, we can't fine government, and that undermines data protection law. So in some countries, you've got regulators saying that their law isn't adequate, and obviously that what's technically called a derogation hasn't been applied by the UK government. And then if we look at adequacy decisions at other countries, Japan, for example, the main criticism of the UK, I think, is the activities of the surveillance services and allegations that Snowden made regarding the activities of the UK security services, in addition to those of the US security services. But you can level those criticisms at other countries that have adequacy decisions as well. Japan, for example, has had, I believe that Edward Snowden was seconded to Japan, and some of his allegations relate to uh, details that he says that he collected whilst in Japan, and there's criticism of the X key score and Mallard systems that in some respects are similar to the criticisms of GCHQ activity, but I think it's acknowledged that there are less protections in Japanese law, Japan having an adequacy decision, versus UK law. So that's when I end up thinking that whilst ever you can look at all of the evidence and weigh it, pros versus cons, it almost ends up in a political decision. And that's when you're spinning the coin, particularly when you don't know what the relationship is between the Johnson government and the Commission. You know, as we sit here today, we're fighting over the Northern Ireland border and the Commission seemingly having made a rather strange decision to enforce the border, having said throughout the negotiations that it wouldn't. I'm not taking one side or another. What I'm saying is that relations aren't great, and you cannot guarantee that they're going to be great in perpetuity.
That's evidence right there that it's all politics as usual, right? Because I always thought the underlying factor was mainly just the state surveillance and some of the issues related around Snowden, kind of Schrems issues that we've seen. But then I can imagine, and I'm not an expert on Japanese government surveillance of data, but I imagine that those issues aren't unique to the UK. So it does seem like it fits into kind of a political peg, if you will. And that brings us to this adequacy decision. Can you give me an overview, kind of unpack in its most basic way, the adequacy decision process? What does a country go through to achieve this designation? Politics removed, what are the steps that a country would go to get that designation from the European Commission?
So I think in the normal world, it involves long lunches and schmoozing. I guess that's happening via Zoom at the moment. But
as most things do, right?
But the applicant country would say, hey, we've got this data protection law and we think it's adequate. And they'd knock on the door of the Commission, the European Commission initially, and the US Commission and the European Commission will do an assessment to see if it checks the right boxes as being adequate. It has to be equivalent to GDPR. It doesn't have to be the same. So once it's past that threshold, what's commonly been the case is the Commission has said to the EDPB, hey, we've got this application, looks good to us, we intend to give an adequacy decision in favor of this country. And then generally what's happened in recent past is the EDPB have issued an opinion where they've said, yep, we agree, no, we don't agree, or actually, we'd rather that you did X, Y, and Z in addition. I think technically the adequacy decisions in the gift of the Commission, not the Commission plus EDPB. It'll also canvass views from the European Parliament. That's when some of the most profound objections might come, because some in the European Parliament believe that they've been surveilled by UK security services. So that's where we might have some of the most emotive reactions. But then the Commission will take a decision. And if it is an adequacy decision, then that's likely to be challenged through the courts, just as we saw in Schrems 1 against Safe Harbor and Schrems 3 against Privacy Shield. But that challenge, I think, is unlikely to be heard unless some expedited procedure is found until probably 2023, 2024 time. I think that there are pressure groups lined up to challenge. Max Schrems has said he's not waiting in that line, but there are other Digital Rights Ireland, La Quadrature du Net, other pressure groups around the EU that have challenged the data transfers to the US. And I think probably one of those groups would be seen as favourite to launch a challenge against any UK adequacy decision.
That begs the question, how much solace does an adequacy decision even give to a UK corporation that's transferring data? In one of your client alerts on the Cordery compliance website, you noted that in this past October, a German court brought an action against Amazon, basically alleging failures to clarify data transfer procedures following the invalidation of the Privacy Shield. So if a court of a member state can take action against UK data transfers during this period and even beyond, despite the fact that the European Commission adopts the adequacy decision finding following approval from all the member state representatives, does an adequacy decision really give me any solace or any kind of real protection, even if it's in place, given this whole kind of political climate?
I think you're right. I think it adds some comfort, but I don't think it adds much more than that. And of course, as well as these big challenges to data transfer, we see micro challenges almost every day, particularly in the area of internal investigations. I can remember even, I don't know, because I'm incredibly old, maybe 14, 15 years ago, I can remember the subject of a fraud investigation saying, hey, but you can't use any of that evidence against me because it was invalidly transferred and safe harbor doesn't apply. So you get inventive individuals and their counsel raising these issues as barriers to doing something they don't want to happen to them, commonly if it's likely to prejudice their own interests. So in US litigation, if an individual is likely to be criticized in that litigation, he might well already be trying to use data transfer as a reason for documents relating to his conduct not to be used in the US proceedings. And it's exactly the same, I think, with any adequacy decision for the UK. And obviously, it's going to be even more complex because the data flows in some cases for many US corporations will be EU, UK, UK, US. So they might even challenge both of those hops, if you like, the EU to the UK hop on the basis of an invalid adequacy decision, and then the UK to US hop on the basis of standard contractual clauses not having been followed properly. So I think that certainty will not exist until sometime beyond 2025, and maybe not even then.
Well, since I never thought of that. So, I mean, I remember back in 2014, I think that's when you and I first met. We were talking about, the conundrum that one faces when you're trying to produce documents in a U.S. court. It's the well-known problem of, do you comply with your U.S. discovery obligation, or do you comply with European data protection law? Now it seems like with this UK wrinkle, there's almost kind of two levels of uncertainty. So it's going to be interesting to see, and I don't see too often kind of early on in the discovery process in the U.S. counsel really highlighting to the court these transfer issues. It often happens at the 11th hour. So I'm wondering if folks are going to become a little more diligent about that. Maybe we could save that for a future panel and bring on some U.S. practitioners. I'd love to bring you back on for that. But
yeah,
let's address.
And just one wrinkle on your wrinkle quickly is that, of course, the distinction between that discussion we had at Georgetown all those years ago and now is the fines are so much higher. So when we were talking then on that panel, the maximum UK fine was 500,000 sterling. Now, if my scenario is right with two hops, you're playing with 8% of your global annual revenue. So the stakes are significantly higher than they were when we sat down with Judge Scheindlin to debate those issues in Georgetown all those years ago.
And that actually reminds me, you're exactly right. So it wasn't 2014, that was 2012.
Was it?
In Georgetown, yep. Wow. No, I
All I
think
can remember is that breakfast, but that's probably not something to go down in a public forum.
yeah, that was definitely an interesting. I still tell that story today. Maybe we'll save that for the deep cuts on the ESI Survival guide. So that's for the subscription membership. But it is interesting, and so you think that there's a chance. So it's the same data transfer. So you're going EU, UK, US. So technically two transfers, but let's say the same data set. Do you think there's any scenario where regulators would ping that entity twice, so they would get both of the, if let's say it was egregious, they would get a double 20 million euro and a double 4%?
I think possibly there's speculation as we sit here today, and these are, I have to say, rumors, and they're unofficial rumors and no public comments so far as I know. But there's a case progressing against WhatsApp where the DPC in Ireland is the lead regulator. Some of the issues are post-Brexit, and the rumor is that the EU DPAs can't agree on the level of fine. So there's been a delayed announcement. I think the announcement was due today. And I think the rumor I hear is that announcement's been delayed. And in addition, the UK seems to have said, well, once the EU is done with a fine, then we'll look at a fine in addition. So there's certainly talk of the double penalty. And if you look at it from the position of the regulators, then a Greek regulator isn't going to want to give up on a case just because the UK's got there first, and probably vice versa. I think eventually we'll get some settling down, like we have with bribery fines. If you look at settlements like Airbus and Rolls-Royce, regulators give credit for the money paid in other jurisdictions. I think eventually we'll have some sort of a mature system like that, but I don't think that's anytime soon.
It's almost like in the criminal context in the States, they get credit for time served, right?
Yeah.
So let's address real quick some of the mechanisms that parties use to actually facilitate these transfers, and kind of how those mechanisms have changed under the current climate. So binding corporate rules, standard contractual clauses, these are two transfer mechanisms that historically were the go-to mechanisms for transfer to third countries. With Brexit, the UK Information Commissioner's Office is no longer a supervisory authority under GDPR, and my understanding is it cannot approve BCRs vis-a-vis the EU. And then the European Court of Justice in Schrems 2 stated that standard contractual clauses, although not invalid, are only valid if the receiving country passes an essential equivalency test. And you kind of alluded to that earlier with regards to data protection. So essentially, it seems like each non-EU data importer has to do their own adequacy analysis. So now there's this assessment requirement. So the EDPB has come out with some guidance this past November, but a lot of it's convoluted. There's still a lot of uncertainty. I think that's the name of the game with everything we're talking about. But if I want to use BCRs and I'm a UK company and I got to do some transfers, this month, what do I do?
If you've got an existing BCR scheme, you're probably okay. If you haven't got a BCR scheme already, probably too late. BCRs are still going to take you about a year, 18 months to get approved through the process. I don't think there's such a big issue with Brexit in BCRs, because I think the ICO is going to respect any BCR entered into prior to the UK exiting the EU, and some BCRs where the UK is the lead authority had joint lead authorities. So some people have, UK and Ireland as the lead authority, and there has been a transition period where those BCRs where the UK is the lead authority, those entities have been told, Brexit's coming. Obviously, they've known about it for 3 years, and they've been making overtures to Belgium or Ireland or the Netherlands, whoever might be the next most appropriate regulator. There's been some wrinkles in that process. Ireland, for example, I know would be the choice of many in the US, but from discussions I've had with the DPC, they weren't that anxious to do stuff early doors. But BCRs aren't the problem that's going to concern most people watching this. Standard contractual clauses are, and you're right, you have to do what we call a double due diligence test. So your normal due diligence against who you're sending data to, is the contract right? Can they afford to pay if they mess up? Are they doing appropriate training, etc., etc.? All of that sort of stuff. And your second due diligence against the location where they are based. So many of our clients are doing that on a more granular basis. California might well be more acceptable as a destination for data than some other US jurisdiction, and that might involve a sort of fairly granular analysis. I think Virginia is proposing new privacy law this week. So what will that what does the existing privacy law look like? What will the new legislation look like? When will it come in? So those type of analyses are having to be done on a somewhat bespoke basis. I think some of the clients we have are trying to catalog that. So if they've done a California analysis, then they'll put that in a library, and next time there's a data transfer to California, they're not reinventing the wheel. They're pulling down the California analysis and stapling that to the transfer. But it's definitely a task that needs doing. Obviously, with eDiscovery, it's relatively easy in that usually it's a distinct transfer, rather than if you're a global corporation with operations in Europe, you might have 470 different processes that you're having to analyze with 470 different data recipients. But you do have to do that double due diligence test if you're relying on standard contractual clauses.
And that's one of the issues you highlighted, is that we often forget about in the e-discovery context, is we often, a lot of the transfer laws were engineered with regards to business transfers and kind of business flow, not necessarily making productions in a U.S. court of law. So oftentimes, even with BCRs, you might be able to get it from your office in the UK to your office in California, but then can you produce that data pursuant to a discovery obligation in a U.S. court? That can also be an extra rub.
But bear in mind the fact we don't know the exact number of BCRs that have been issued, but there probably not that many have been issued post GDPR or been approved post GDPR. I think the majority were approved under the pre-GDPR regime and have grandfathered across. And in any event, we're probably still less than 150. For most organizations, the rubber hits the road with standard contractual clauses, particularly in an eDiscovery scenario. And I think it's certainly open to a regulator to get granular. There is some talk that California could even apply for an adequacy decision in its own right. And effectively say, let's just say the words stuff you to the other US states and go it alone and try and get its own adequacy decision.
So I'm not going to have you define the British meaning of stuff you, but we'll but I mean, that's really interesting. And also, I guess practically, I assume it's pretty rare that you would see an enforcement action in regards to kind of BCR violations intra-company, if you will. I assume that's not high on regulators' list in terms of that. It's usually kind of data being transferred outside of an organization, although I can see it happening.
I don't believe there's been any challenge to BCRs.
Right.
In a case I'm not going to go into, we have threatened it. And we got close to it, asking a DPA to investigate compliance with BCRs that it had approved. But thankfully, the organization that we were dealing with saw sense and helped us set up an inquiry to look at those concerns. But there will undoubtedly be a request for BCRs to be to be opened up if that hasn't happened already. But again, timing, these things won't happen quickly. Even if I complain to a DPA about somebody's BCRs today, that investigation might not be public for another year.
Right. So let's turn to standard contractual clauses. So same scenario. I'm that same UK company. BCRs are out of the question. I haven't made an application pre-Brexit. So my normal go-to was I had contractual clauses with all my vendors in the States, everyone I transferred data to. What do I do now? How can I leverage SCCs in the context of today?
I think it's still the same as people were doing after the last Schrems judgment. So it's still trying to limit data where you can, and then relying on double due diligence where you can't. And in some respects, of course, we can go back to basic GDPR principles around things like limiting data. If you're going to cull data, then you stand more chance of being compliant if you can do that cull in the jurisdiction rather than export to the US to do your cull. And that's good from a data transfer point of view. It's also good from a general data protection point of view with other principles in GDPR about proportionality and adequacy, et cetera, et cetera. So I think you're going back to basic principles of, do we really need the data in the US? If so, is there a smaller subset that would do? Can we locate the data in the US anyway? So, for example, with emails, if the recipients are in the US, you may not need the emails from senders who are in the EU or the UK. And once you've done that piece of work, then look at the transfer of the remaining data. And standard contractual clauses are probably the only game in town for you. So you've got to do that double due diligence test. And that will include looking at which state it's going to in the US as well, I think.
And using the whole metaphor of the ESI Survival Guide, so some survival tips in there. We've long talked about in-country culling and filtering, but I think in the context of standard contractual clauses, we're looking at doing this equivalency test or this kind of adequacy assessment, and then doing a lot more kind of focused, targeted culling and filtering in country with UK data, probably more than we did before pre-Brexit. Would that be a tip you'd agree with?
Yeah, I think that's right. And I think the other thing is have some realism. There is no perfect solution to this. Even if you do a state-by-state analysis, of course, the law that most in Europe complain about is federal law. So that so in some respects, what you're trying to do is like that little Dutch boy, stick your thumb in the dike and hope that it holds, or at least holds long enough for you to do what you've got to do. So you're trying to prove to a regulator that you've made best efforts rather than seeking perfection, because perfection doesn't exist.
So the subtext of all this data sharing post-Brexit that we're talking about, and whether an adequacy decision will issue, is of course government surveillance, whether by the Secret Intelligence Service or other intelligence services that process data, MI5 and government communications headquarters. Two countries in particular that I'm aware of that have already expressed concern over sharing criminal conviction information with the UK are the Netherlands and France. But again, government surveillance underlies the larger issue. We see Schrems 1 and 2. And then you've seen in the press, whether it's just it's my ball, I'm going home, or it has any kind of heft to it, is the whole notice of Facebook threatening to leave Europe. And then on the flip
Australia.
Side, yeah, and Australia. And on the flip side of surveillance, you have national security concerns. These have underlined a lot of the press around the former Trump administration's ban on social media platforms like TikTok, which has been subsequently blocked by federal judges in Pennsylvania and D.C., but challenges against WeChat and whatnot. And you've seen this dubbed in the press as the social media, kind of data wars. Now you're seeing real challenges to tech, where they're having to localize, in effect, their operations which we've never really seen before with regards to the internet and to the cloud. Do you expect the law to cave to technology as it often does, or are platform developers really going to have to build around these issues and consider how they function in a more localized manner to comply with these evolving pro-privacy frameworks?
I think you get real issues with the regulation of big tech, and of course some of GDPR's provisions. I think the underlying current behind them was an attempt to discipline big tech. If you look at the right to data portability in GDPR, for example, the right to move data from one place to another. If you look at the origins of that, I think it starts off as an antitrust measure. Big US tech corporations are so big, how can we make it easier to migrate to another platform? And so it fails as an antitrust measure, so it gets slotted into GDPR. And there's some sort of logic that says that somewhere in a back bedroom in Dusseldorf, there is a new founder of a new Sergey Brin, a brilliant person there waiting to set up a big tech company. And the only reason he can't get out of his apartment and do that is because of the dominance of Facebook and Google and Microsoft or whoever. And there's this frustration that the antitrust cases, whilst they've had high fines, haven't really punished those big tech operations. They've been pinpricks in the side of an elephant that's still charging. And I think that's going to be a perennial battle for the UK, for the EU, for whomsoever. And without name dropping, I interviewed a few years ago Max Schrems, and we had a really good discussion on this. And I think our view, I do agree with him on this, is that the only way that the European organization, for want of a better word, can discipline the big tech organizations is by looking at this sort of triangle of relationship of regulation. So looking at privacy, looking at fair trading laws, and looking at antitrust laws. And when regulators coordinate and look at the perceived issues around big tech, then they might make inroads. But until then, not. You look at the UK's enforcement action against Facebook, admittedly under the old law, not the new. They decide that Facebook has had this liaison with Cambridge Analytica that's unseemly and unlawful, and they decide to fine Facebook the statutory maximum, which at the time is £500,000. I mean, how I don't see Mark Zuckerberg going home and saying to his wife, no vacation this year, honey. We've just been fined £500,000. Yeah, I don't see that happening.
He's like, go into the glove box and get me the payslip to there so I can pay this fine.
Yeah. So where I think regulators have got cuter against the likes of Facebook is, I don't know whether you're familiar with the Facebook dating case in Ireland. Mm-hmm. I think a really interesting use of a regulator's resource where they say, okay, Facebook say Valentine's Day 2020, we're going to launch Facebook dating. And they tell the regulator 10 days ahead or whatever. Regulator says, interesting, shows your data protection impact assessment. And Facebook say, and we don't know the full facts, I'm assuming what's happened, but I think Facebook say, yeah, data protection impact assessment. And the DPC knocks on the door and says, show us it. And whatever happens in that discussion, we don't yet know, but it leads to Facebook pulling the launch of Facebook dating across the EU. Now, why is that impactful? because, of course, the biggest gold rush as we went into the pandemic was online dating. And Facebook were effectively removed from that market. And that hits them more than any fine can. They've lost opportunity. They're not in the big growth market for advertising. And all of those little dating operations that they were hoping to knock out of the water get stronger in that 6-month window that they've got or whatever during the pandemic. They're making cash and they're more robust and more able to defend the soldiers of Facebook when they're let out of the gate. So I think we're going to see regulators act much more in a much cleverer way, and that is relevant to eDiscovery as well, because one of the biggest nightmares in eDiscovery would be a public prohibition for a law firm, for example, saying that it cannot transfer data from the EU or from the UK to the US. That would be more impactful on their business than a likely fine in most jurisdictions.
I used your term before. I don't know if it applies here, but that micro challenge. It's almost like death by a thousand cuts. We often focus so much on the privacy issues. We don't even consider the fact that privacy could be an end around to these antitrust type issues. It's almost like with Al Capone in the States.
Yeah.
They couldn't get him on murder, so they got him on tax evasion. That's really interesting to think about, is how regulators combine these creative approaches to actually deal with the monolith that is Facebook or Google or whatnot. I think for privacy advocates, it gets a little bit maybe disheartening, because you expect that really it's privacy is the reason why everyone's doing this, and the benefits it has to the individual consumer and our own personal data. But at the end of the day too, if the end result is the same, I think it benefits everybody. So that's really, really interesting. And talking about enforcement, obviously actual enforcement by the UK ICO, it seems to be fairly rigorous. You have penalties levied against British Airways and Marriott International in the past months. I think this past October, Ticketmaster UK Limited this past November. So obviously the UK is serious about enforcement, which again I think would bode well for an adequacy decision. But that being a factor, but the UK clearly shows their intent to follow GDPR style privacy protection principles, despite all of this heavy talk and fighting words you often hear in the press. Doesn't that bode well for kind of a reunification of the privacy front between the UK and the EU, European Economic Area, that the UK is almost draconian on its enforcement, that if that jives with what the EU is doing, maybe that's a meeting point where they can bridge these issues?
Yeah, you'd hope so. I mean, as far as the pure numbers are concerned, then I think the UK is pulling its weight. I think the right figure is 272 million euros in fines across the EU, not including the UK, in 2020 versus 40 million sterling-ish in the UK. And now, obviously, some authorities enforce more frequently, but for lesser amounts. Spain, for example, in 2020 bought many more cases, but of lower value. It's obviously got a couple of big cases recently, with CaixaBank being one. But in monetary terms, I think the UK regulator has pulled its weight. And I know privately that a number of DPOs in Europe regret the fact that the UK is out of the picture as far as investigations are concerned, because they tell me that the UK pulled its weight substantially in investigations as well. So for a time, I believe the technology lead on investigations across the EU was somebody effectively seconded from the ICO. And the ICO is a well-resourced operation versus many other data protection regulators. So I think of enforcement across the EU is the poorer for the UK not being there. The other thing to worry about, whilst we're on that, is that in some respects, the UK has been a voice of sanity sometimes, or has allied with other regulators or governments to have a voice of sanity, and that's helped sometimes for businesses, for example, add some almost like, so that we don't have absolutism in privacy terms, so that we can take other things into account. For example, the pandemic, the UK is relatively generous on allowing companies to allocate resources differently during the pandemic, where other regulators haven't been so generous. And already we're seeing new proposals to toughen GDPR, because I think some countries and some individuals are thinking now the pro-business or the balanced business, depending on whose view you take, now that block is weakened, the pro-consumer, pro-employee block has more power. So we can introduce some of these new proposals to add into GDPR, like, for example, a mandatory ban on asking employees to read emails out with working hours. We've got more chance of adding that to next generation GDPR and cranking up the dial on corporations as a result.
You've heard it here, folks. I'm going to let you try and trademark next generation GDPR, which is also the title of the worst science fiction show ever.
That's right.
but so in talking about enforcement and even making GDPR even more restrictive, I remember when, as we said before, when the penalties came out. It's 4% of annual turnover, 20 million euro for the more egregious actions, and half that for kind of less so. You've seen EU courts reducing these penalties levied against entities that have run afoul of GDPR. What do you think of that? Do you think that that's kind of a reaction to either the uncertainties of GDPR or these, what people might say, are draconian penalties? And also, that begs the question, could a UK court invalidate a penalty levied against a UK company for violations of the GDPR? Could you see that action happening in the courts where you're having that kind of battle between the UK and the EU?
Yeah, the second one's almost your ultimate nightmare, and I think we probably will face that. And I think that as far as I know, the BA and Marriott cases won't be those test cases, but there could be some. The UK, as part of the temporary deal, the UK is committed to observing EU case law from pre-Brexit days. So, and there are all sorts of caveats on that. So higher level courts at the moment need not necessarily follow it in some cases, and that may go down the court sphere. So we're in this odd limbo land, if you like, as far as appeals are concerned. But appeals have been successful. Appeals and reductions, we did a snap survey on this, which isn't scientific, but we looked at appeals and reductions last year, which sit at around about 302 million euros in appeals and reductions, and some of them in percentage terms are fairly spectacular. If you look at the 1&1 case in Germany, 9.5 million euros goes down to 900,000 euros. You mentioned Ticketmaster earlier. My understanding is Ticketmaster are appealing, and that might be one of the tests of how does all of this stuff fit together, and where is the appeal to? Is it to a UK court who has to apply EU law? Is it to an EU court who knows? I mean, there's no doubt academic papers being written written on that as we speak. But what we do know is that there is a good hit rate on appeals. If you can get to a court, whether that be a domestic Austrian court, a domestic German court, a domestic Swedish court, then we know that the courts are reducing those penalties. And we also know that making representations to regulators after a notice of intent is served, like in the BA and Marriott cases, can have reductions as well. And we also know, and from the recent Twitter case in December involving Ireland, that Europe isn't at one on these issues. I can't remember it off the top of my head, but if you look at the banding that was proposed by different EU data protection regulators, I think it goes, don't quote me on this, from around about 100,000 euros to about 25 million euros. You know, there's no consistency in the levels of fine for one given incident across countries. As I said, countries like Romania and Spain do a lot of cases at low value. Countries like Germany, the UK, France, fewer cases, but with higher fines. There isn't that consistency that some thought GDPR would bring.
Right. It's definitely going to be interesting to see kind of in the near future, kind of the money battle that happens. And something you said before definitely brings up, I want to give a shout out to all of our folks in comparative law academia. It sounds like a lot of what's going on now has created some significant job security. So I'm sure everybody's just cheering in those departments. But, you know, talking about kind of business and these regulatory actions, you're seeing co-regulatory models crop up in privacy regulations. You're seeing Canada has a recent bill, C11, which enacts Canada's Consumer Privacy Protection Act. These co-regulatory models allow for certifications and codes of conduct that are basically intended to marry the benefits of industry sector development of rules and standards. Like, you know, they have specific expertise, they're more flexible with the authority and accountability of the state regulatory authority. So, you know, these co-regulatory models have ideally are kind of pooling the best of both worlds. And then in GDPR, you have Articles 40 through 43 that essentially set the stage for co-regulatory efforts. So, you know, in light of the uncertainties that are still present in this global regulatory landscape, in light of in some of the fighting words we've seen, however strong, it's that, you know, that seems to kind of highlight a divergence between industry and the regulators. But you know, isn't cooperation between these two groups, you know, really the answer to these issues, if not extremely vital to move forward? And are you aware of any actions that are occurring with you know, industry and the regulatory bodies trying to work together on that front?
I think progress has been slow, to be honest. I think that individual cases have taken standards into account. You know, so if you've got ISO accreditation, then that will be taken into account when assessing a data breach. But I think as far as, you know, formal certification programs are concerned, then my feel is that progress is slow. I know people are talking to regulators, both at a national and at an EU level, about potential self-certification schemes and potential, as you say, the powers exist under GDPR for industry-led schemes, etc. But I don't see a lot of chatter about that at the moment, to be honest.
Right. Well, hopefully we'll see some of that. I mean, in my opinion, is that you need that marriage, or at least that relationship of sorts, just to inform the way the regulations are drafted, especially as tech gets more complicated. So as we come to a close in what's been a very interesting interview, and Jonathan, I can't thank you enough. You know, let's close on the question, at least our substantive part of the interview. You know, what are the 3 items in your post-Brexit survival kit?
Yeah, so I suppose I could give you a sensible answer or a slightly comedic one. I think if I was looking at a sensible answer, then obviously I've got to look at clarity. So I've got to be clear about what I'm telling my staff, my consumers, for the type of litigatory risks we talked about with the Amazon case in Germany. I'd obviously want to keep doing that double due diligence test and apply it to the UK as well. I probably want to watch out for subject access requests as well, because they're on the rise during the pandemic. Slightly more lightheartedly, I think if I could have three things, first of all, I need my passport. There's no when we're allowed to travel again. I don't actually know where my passport is for somebody who used to travel a lot. I haven't been out of the UK since, I don't know, February. I think the last time I came over to see you, so February time.
Oh, wow.
So passport. Um, I was always, as a mildly amusing story, one time, I'll tell you the full story another time. I once had to go and give a talk for a colleague in Paris, and nobody had told me that I'm replacing, obviously, a French colleague, that the conference is entirely in French. And so I turn up, and it's thankfully a topic I knew pretty well, and 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 bizarrely, it's a big conference that also has an art show. So the curator of the art show is showing me around the art show as he's showing all the keynote guests. And obviously, he thankfully went to say to the organizers, "I'm not sure his French is great," and so they got a translator, which is all perfectly fine, all good. And I literally had stood in at 24 hours notice, so it's slightly chaotic. And then they invite me to this beautiful, beautiful dinner in Napoleon's library.
Oh, wow.
But they've sent the translator home, and so and so I struggled through the dinner, and they're talking about. I can remember one of the discussions, I kid you not, was about poison pen defenses in French corporate transactions, and I was so pleased that I'd worked out the topic. I couldn't contribute, but I was just so pleased with myself that I'd worked out they were talking about poison pill defenses. And I tried to do my best. And the person next to me put her arm on my shoulder at the end of the dinner and said, can I just say that your restaurant French is almost perfect? You've been able to order things. You've been able to say whether you want it with sauce or not.
As long as you do the menu, it's all good.
If you're gonna talk about corporate, poison pill defenses with French corporate lawyers, you need a little work. And then she said, however, if I could do one but not the other, stick with improving the restaurant French. And so that's the other bit of my Brexit pack. I'd want to take with me my restaurant knowledge, because even if I can't correct the wrongs of the Boris Johnsons of this world, at least I can get dinner.
Well, I thought you were going to go with number two being the universal translator, but you went with restaurant knowledge. So interesting, but I think a much better option and a much more aptly used option. Okay, so you got your passport, you have your restaurant knowledge. What's number three?
I would cheat if I can, and can I have a hotline to my colleague Andre Bywater on the basis that he's worked in most of the EU institutions, and there is rarely a question about Brexit that he doesn't know. He worked on some countries joining the EU, so obviously nobody knows the exit process, but we've been able to work out some stuff by knowing what the entry process was and reversing it. So I'd have a hotline to a colleague if that's allowed.
Hey, of course. I mean, that's a satellite phone, so that's an item. So you got your passport, you got your restaurant knowledge, and you got your satellite phone. I'm surprised you didn't say COVID vaccine, but I think that goes down a whole other rabbit hole. But fair enough. I think that's a great survival kit. And just as we come to an end here, I did have to ask you this question because it has become almost all consuming for me. During the lockdown in the States, obviously people are watching lots of television, lots of Netflix, and I just want to find out, because oftentimes when it comes to popular culture, we often think we know what our friends across the pond like, but it's not always the same. Are you as obsessed with the Great British Baking Show as I am?
I have to tell you not. I think my daughters were pretty impressed with earlier seasons, and I know that they have. We had to go to a supermarket one time to meet the winner of one of the earlier seasons, and I know that they insisted that their school get close to a winner from another season as well. I think we've moved on from that in our house. Our guilty pleasure at the moment is Married at First Sight Australia. I can't recommend it highly enough.
Awesome.
And it's also given me a new word for the Australian viewers, of which I'm sure you have many. It's made me learn to not be a gillar.
A Gila. Is it pronounced like that? Gila.
I think so. I'm
You have
learning
to
my
get that.
Australian. Obviously, I've nailed down my Australian restaurant, but now I'm trying to go through the rest of my Australian lingo.
I've been obsessed, especially with the Noel Felding and Paul Hollywood Great British Baking episodes. But fun fact I realized is that in the UK, it's actually the Great British Bake Off. In the States, it's the Great British Baking Show, because Pillsbury, not the law firm, but
The dough makers.
baked goods dough makers, owns the trademark to the phrase bake off.
Really?
Yeah, so they couldn't, and I guess just in the States they couldn't use that. So if there's one takeaway from our talk about data transfers to and from the UK, it should be that Pillsbury owns the trademark to bake. But so, in all seriousness, thank you so much, Jonathan. There's so much more I'd like to talk about. Hopefully, you'll come back for a future installment. Hopefully, regular sessions, actually. I cannot say emphatically enough for folks to go check out the Cordery compliance site. There's so much great knowledge on there, so many great resources. That's what this site is all about, is giving you all resources that you can use day to day. I'm going to post some of them on the site. Jonathan, you actually mentioned that you interviewed Max Schrems. Is that interview recorded? Do you have that available?
No. There's a long story behind that, but no, there's a summary on our website.
Okay, fantastic, because I think that a lot of our viewers find that very interesting. But some other topics I'd like to explore in the future, the one-stop shop mechanism under GDPR, privacy and electronic communications regulators, as well as the good old-fashioned American rock and roll versus British rock and roll, which I think we could probably talk about for even longer than we did this. So, Jonathan, I want to thank you again. If you have any final comments.
No, thanks for watching, and a gold medal to everyone who stuck with it.
Well, wonderful. So thank you again. This is Matt from ESI Survival Guide, hoping that all of you stay safe in the electronic wilderness. See you next time.